So what if you need to have access to your property before the redemption period is up? Hi, my name is Julia M. Spencer. I'm a real estate advisor, investor, and your #1 source for real estate advice online. So with this video, we're going to talk about a very specific question I had on my YouTube channel. Actually, it was an email that was sent by a subscriber, and he is one of the people that have actually bought a couple of tax liens in Augusta, in Columbus, Georgia, and in August, which is only for like 9 months ago, close to redemption period is close to being up. And anyways, this investor received a letter giving him 2 options for the properties that he bought, and 1 is you have to tear it down, and 2 is you have to repair and make it be in a livable condition. And basically he's asking me what he should do, because in the state of Georgia you don't really have access rights to the property, so you can't actually go there and step foot on the property until the redemption period is up, and you have barred redemption rights and gone through a legal process of either foreclosure or some sort of eviction if somebody lives there. So in any case, he's getting this letter from the county, I'm presuming, telling him to tear it down or repair it to a livable condition. So I'm presuming the properties are in really, really bad shape, which a lot of times happens when you buy tax liens. So his question to me is, can I do anything to the properties before a year, or can the city give me a letter demanding such before the 1-year period? Please let me know your thoughts when you can. Thank you very much. Alright, so here I'm going to answer this question. Who did you buy these properties from? If you bought them from the county, and subsequently in the question you asked me that you actually looks like you are getting the notices from the city, it is very well likely that the 2 taxing authorities don't actually talk to each other. So the city that sent you the letter doesn't actually know that you're the investor that purchased them at the tax sale, that you're in a redemption period and all that stuff. So it's likely it's not the same taxing authority, but also it could be a completely different department, like a property maintenance department. They don't talk to the taxing authorities a lot of times. So what do you do in this case? So, and this actually happened to me exactly the same way for several years ago. So preventatively, the one thing I want to say to you is preventatively try to buy properties that you think may hold up to the scrutiny eyes of the property management companies or property management departments of the city for at least a year, so you don't have to worry about it too much. That's kind of preventatively, but you already passed that stage. So the second option is they're giving you the options to tear down, repair to a livable condition, but you can't do that because you really don't have access to them, or technically you're not allowed to trespass without having access rights. So what I have done in this case, you can do one of 2 things. Contact the people that sent you the letter and try to basically negotiate something with them. A lot of times the reason these letters are sent out because somebody complained and the property is an eyesore to the neighbors and to the property maintenance department, and they don't know who owns it, so they just send whoever's on the property card, they send that letter to, so they don't really know, nobody really knows anything. So find out who sent you that letter, who the inspector is that inspected the property, and try to talk to them. Try to reason with them and see if you can get kind of like a stay on this order, at least until you're able to go past that year, and kind of explain to them that, hey, I would love to go on the property and either tear it down or repair it to a livable condition, but I don't have access. Legally, I don't have access. And can you give me a couple more months? In this case, it looks like till August, which is only like 2 or 3 more months or so. Ask them if they can just stay on that order for a couple more months, and then kind of stay in touch with them and kind of update them on the situation. Because if the original owner still redeems, so you can still redeem until August, then that way at least you haven't spent all the money to do either the tear down or the repair to livable condition without having any chance to actually keep the property. So negotiate that with the property maintenance department. If they're unwilling to reason with you, and I'm going to tell you 9 out of 10 times they will grant you that extra time, it is unlikely that they will not try to negotiate some sort of resolution with you on that. But 9 out of 10 times they will give you more time to handle the situation. The one thing that you can do too is, which is what I have done, is I went to the property with my contractors whenever I got a letter like this before, and actually there's a video on that on my YouTube channel where I'm standing in front of that property. I'm going to put that at the bottom of this video so you can see it. But I drove to the property with my contractor, and I didn't tell my contractor to do it, but my contractor walked around the property and looked at it in very close detail to see if it's a building that can be salvaged or if it has indeed to be torn down, and basically just given me an idea of its shape, and then basically told me what he thought. In my case, the building would have been a tear down anyways. So what I did is I spoke to the city. I asked them to give me more time. They gave me more time, and within that time then I ended up losing my investment, but I gave the property back to the original owner, and I lost my money on that. So that was a bad thing, but it was a way to get rid of the property. You can also donate it to somebody that may want it. You can actually assign your sheriff's deed to somebody else that may want to do something with it. Either way, the first thing you have to do is talk to the property maintenance department and ask them to give you more time. If they don't give you more time, then get rid of the property and you just learned a really expensive lesson. I don't know how much money you spent, but I wouldn't let that sit on me, because what's going to happen next if you don't abide by their requirements to tear it down? The city's going to come and tear it down, and they're going to send you the bill, and then you won't be able to get rid of it at all, because you can't donate a big tax bill when there's not even a building there. You can still donate the land though, so you kind of have to just wage it to see how you want to handle it. So just in summary, if I was you, the first thing I would do is call the people that send you the letter and negotiate them for additional time. Explain to them you're a tax lien investor. Tell them when your tax lien is up. Tell them also that you need probably at least another month or two after the year to be able to borrow redemption rights or do anything else with it, so you have access to the property. And then within that time, then I would decide if you're going to keep it, are you going to sell it, are you going to tear it down, are you going to fix it up, or are you going to just lose your money and give it back. So first thing, talk to them, talk to the property maintenance department that sent you the letter, negotiate for more time, and in that time decide what you're going to do with that property. So that is my advice to you, and hopefully you're able to subscribe to my newsletter. It's at my website, juliamspencer.com, and make sure that you check out my ebooks on this and many other topics, and happy investing.
For your free guide to real estate investing, visit juliamspencer.com.